Today's webinar will be on foreclosures and short sales. Our presenter, attorney Andrew Moore, will provide you with updates regarding the process. Before getting started, did you know there will be new and revised standards forms released in a few days? Be sure to register for this Friday's Chit Chat with Gov Hutchinson, who will go over the new and revised forms that will be released on June 22nd. Currently, there are 13 forms listed on the form summary released by CAR. You will not be able to use a prior revision for 8 of those forms. Make sure you are prepared for these changes. Register today at www.nsdcar.com/webinars. And now, attorney Andrew Moore.
Thank you. Good morning, everybody. My name is Andrew Moore. I'm a real estate attorney in San Diego. I've been practicing about 12 years now. And my primary area of practice is helping people that are facing foreclosure. And there's a lot of changes in this area right now, given the way the world is adjusted to the coronavirus pandemic. So what I'm going to do today is to go over a couple things. I want to go over the process for foreclosure under California law. I want to go over my experience for a lot of my practice, which is people calling in and they'll say, you know, I'm facing a foreclosure sale or I'm in foreclosure. What do I do? What are my options? So I'm going to go through very, very briefly an overview of some of the things that we can do to help clients. It's important from the real estate side too, because a lot of these people are deciding whether or not to sell their house, whether they have time to sell their house, and so forth. And so it's important just to kind of have an understanding of the big picture and to be able to advise them or show, you know, you can't give legal advice necessarily, but be able to point them in the right direction and to understand, for instance, how long you have to sell, what things you can do to postpone sales, things like that. And then the last section of the presentation is going to be much more on the developing rules and protections for homeowners under the coronavirus pandemic. There's federal laws that have come into place. There's some state protections. There's some developments going through the California legislature right now. And all of those are important to know. I'm not going to be able to give you know, a lot of the answers yet, because a lot of this is pending and it's a moving target. But it's going to be important to continue to monitor these things, and I'll at least be able to give some of the bill numbers, some of the information on that, and be able to advise on where to look generally. Now, there's a couple things I want to go over before starting. Most of this presentation has to do with residential properties. There's a lot of different rules that apply to commercial properties, apply to multifamily properties, things like that. I'm happy to answer any questions if you want to email me after the presentation or ask any questions during it. I'll be able to go over that. But as a general rule, this is going to apply to a single family property, someone who comes and says, you know, I want to sell my house or I want to sell my rental property, things like that. That's what this is intended to provide guidance on. The other thing I wanted to talk about is that this is a kind of a lot of material to get through. My preference would be if you guys would be able to chat me questions during the presentation. I would be happy to look and answer as many of those as I can. I'd rather have it be more interactive than just running through the slideshow. So if anything comes up or you have a question about something I went over or didn't go over, feel free to put a chat through and I'll try to answer the questions that way. So to begin here, I wanted to talk about the foreclosure process in California. I apologize in advance. I know a lot of you probably know this information pretty well, but this confuses a lot of people. It confuses a lot of homeowners. It confuses a lot of agents. It confuses a lot of lawyers as far as the timelines, what you can do, what you can't. And the most important thing to be able to help someone facing foreclosure to sell their house, to short sell their house, or in any respect, is to understand when the foreclosure is going to happen, what can happen, what the bank can do, and what they can't. And that's why I want to go through the process fairly quickly here in the first part. So there are two types of foreclosures in California. There are judicial foreclosures and non-judicial foreclosures. And the non-judicial foreclosures are also called trustee sales. I think in 12 years of practice, I've only encountered a couple judicial foreclosure situations. Almost all of them are non-judicial foreclosures, but I'm going to go through both types very quickly just for background. The judicial foreclosure is a court process. And so in a lot of states that, other than California, the only way you can foreclose is through this process. So a lender would have to go, a bank, a mortgage, would have to go to court and say, here are all the documents, here's the documents that the borrower signed, here's the default, here's why we're able to foreclose under the law. We have proven our chain of title, we have proven all the assignments, everything is you know, within the way it needs to be. And so we're asking the court to go ahead and foreclose. And like I said, a lot of states are judicial foreclosure states. California is considered a non-judicial foreclosure state or a trustee sale state. So you can still do judicial foreclosure in California, but it's extremely rare. I don't know how many times anyone has seen these, but they're typically for very, very high-end properties, and typically the properties are very underwater. And the reason the bank would choose to do a judicial foreclosure would be because they would be able to collect what's called a deficiency judgment with the process of the sale. So in other words, let's say that you know, a property is worth $2 million and the loan against it is $4 million. And so it's $2 million underwater. A bank might look at that and they might say, well, I could foreclose in the normal process, but as we'll discuss in a minute here, you won't be able to get any of the $2 million back that you're owed. That's the difference. So you'll end up with a $2 million property and nothing to collect on. They may say it's worth $100,000 or $200,000 in attorney's fees and the court process and the delay and everything else to go through this judicial foreclosure in that situation, because now I can collect against the homeowner. Again, it's very, very rare. You have to have a perfect storm of circumstances. You have to be justified and have it be worth it from the bank's position. And it's just very, very unusual for you know, normal properties that you experience in an everyday situation. So that's really all I want to get into with judicial foreclosures. There's a couple of other things, you know, that should be talked about with that. If a judicial foreclosure happens, for example, the borrower can come back sometimes and redeem the property. So in a normal foreclosure, when it's gone, it's gone. You can't get it back. You can't pay for it again. With a judicial foreclosure, you have sometimes a right of redemption where you can come back and buy it after it's sold. But again, that gets into very complicated situations that are very rare. So if that ever comes up, feel free to email me. I'd be happy to talk about it. So there's a question that came in and it says, I thought California was a non-recourse state. That is referring specifically to trustee sales. So I'm going to get into that next. Normally, in basically every situation we have, it is a non-recourse state, which is also kind of defined under the same umbrella as the one form of action rule. So I'm going to get into that right now. So the most common type of foreclosure is a non-judicial foreclosure. That's the vast majority, and it's the power to do the non-judicial foreclosure process is contained in the power of sale clause in the deed of trust. The trustee sales, as per the question I was just asked, are subject to the one form of action rule. And so again, want to make sure there's no confusion. The judicial foreclosures can have deficiencies, but the trustee sales cannot. And so trustee sales, there is no deficiency. Take the same example. You got a $2 million house, you got a $4 million loan, and the loan forecloses. They get the house, but they can't come after you for the difference. And that's the one form of action rule. You can take one form of action. You can either collect on the debt or you can foreclose. And in a kind of interesting twist under California law, they've found that you have to go after the property first. So in essence, the one form of action you're allowed is the foreclosure action. There's not really, if you're underwater by $2 million, they still have to foreclose. They can't go after you individually and say you can keep the house, but you owe me $2 million. And that's the way it plays out in real life. So the process for the non-judicial foreclosure, which again, I'm sure we've all experienced, and this is extremely important because a lot of borrowers misunderstand this, is pretty straightforward. Once you default on a loan, normally it's a missed payment, sometimes you don't prove insurance and things like that, but it's in almost all situations, it's because you fell behind. The lenders will start mailing letters, start calling you saying, you know, I'm behind, you're behind. Would you like to apply for loss mitigation? We can look into a loan modification. We can do X, Y, or Z. You can do a repayment plan. You can reinstate, things of that nature. When they start mailing those letters, a lot of times they'll say, you know, you are in default on the loan, or you are delinquent on the loan, and things like that. A lot of people that are in homes, homeowners, they'll believe that that is a notice of default. So if you ask them, do you have a notice of default? They'll say, yes, I do. You want to ask to make sure that the actual notice of default, the NOD, is what you think it is. Because a lot of people say, I'm about to get foreclosed on, we don't have time to sell, I'm just going to let it foreclose, or I'm just going to do X, Y, or Z, and they may have 120 days before it forecloses and have plenty of time to sell. So the notice of default, the official one, happens at least 120 days after the initial default, and it's mailed by certified mail and recorded with the county, and it's captioned on the top of it. It says notice of default and election to sell under deed of trust. And that's what makes it a notice of default. So again, a lot of confusion over what a notice of default officially is. But once that is filed, the notice of default, the official one, that actually starts the foreclosure process. And then you're officially in foreclosure. The timelines have started. You've got to be ready to take action. And you got to, look at your options during that next period. The notice of default itself, it must identify the property. It must explain what the breach is. It must provide the contact information for a trustee, which I'll talk about in a minute. And it must provide the amount necessary to cure the default as of that day. So what banks do, what servicers do typically in a foreclosure situation, is they'll kind of farm out the actual foreclosure process to a third-party firm. They're typically called law firms, but they're not really lawyers you could talk to, and they don't really have any power to do anything other than inform you about the situation and conduct a foreclosure sale. So you got companies like Recon Trust, Cal Western Reconveyance, companies like this that you probably dealt with. They're the ones who actually conduct the foreclosure, and again, they're not able or don't normally have the power to do anything. So you could call them and say, I'm working on the sale, we just need 30 more days, it's an escrow, and almost certainly they'll say, I'm sorry, the sale's for Friday, talk to the lender or the servicer. If they tell us to postpone the sale, we'll postpone the sale. So they're the important party to understand what the most current foreclosure information is. But as far as anything, making progress, doing anything to postpone a sale or to deal with the actual loan, you're going to be dealing with the servicer. The trustee, though, is a very, very important resource. They issue a trustee sale number on the notice of default, and you can always look. Most of them have websites now. You can call them and you can say, when is the sale date on this property? Is it, June 30th? Did it get postponed to July 30th? Sometimes they'll tell you if the lender has requested a postponement. They're a very important kind of safety valve for this whole situation, because if there's a confusion about when the actual foreclosure sale is, and there is more confusion than ever these days, it's really, really important to have that resource. And even if the bank says, we're going to postpone the sale, or we're going to request a postponement, you want to verify it with the trustee. Because if it's not verified and if it doesn't get postponed and the house forecloses, everybody loses, the clients get upset, and there's just a lot of confusion over how that could possibly happen. We'll talk later about some of the coronavirus advancements and some of the things that are going on. But there's a whole lot of confusion. A lot of people have come to me, a lot of homeowners, and said, well, they can't foreclose, there's a moratorium, or they can't foreclose. They couldn't possibly foreclose during the coronavirus pandemic. And unfortunately, banks just don't think like that. They typically are looking out for themselves, and from their perspective, they're facing potential extreme delays if legislation gets passed forcing the foreclosures. So some of them are almost expediting them if they're allowed to. And there's some loans they can foreclose now, there's some they can't. We'll get into that at the end. So after the notice of default is filed, the borrower has 90 days to cure. It's important, and again, I know this isn't typically what you're going to be doing day to day, but it's important to understand, because some clients will say, well, I'm going to cure this, and then we have more time to sell. And then they say, well, I paid the amount on the notice, but they're still foreclosing. That happens a lot. When the notice of default is issued, it says, you owe $32,397 as an example. Through this date, plus any fees and costs incurred in the future, up to the date of reinstatement, including interest payments, including whatever else. So if you're going to cure a default as a borrower, you need to call the trustee or the bank get the updated reinstatement quote and make sure you cure it to the penny. Otherwise, they legally have the right to continue with the foreclosure even if you get close. As crazy as that sounds, it's happened. And so you just want to be sure about that and make aware, you know, how long you have before the foreclosure sale. If it is cured, the foreclosing party has to rescind the notice of default, and then you're out of foreclosure. And then if you were to fall behind, the whole process will start again. If the default is not cured, the foreclosing lender can go ahead and file a notice of sale. So they have 90 days. You have to wait, give you a chance to cure. After the 90 days, then they have to set a notice of sale. It can be 21 days or more later. And that's the foreclosure sale date. So at that point, the timelines kick in even faster. You only have a little bit of time to reinstate. There's a very interesting rule under California law that a lot of people aren't aware of and is very, very rarely used, but it's important to know. Once they issue the notice of sale has on it the entire amount due. So the notice of default says you're behind $35,000. You can cure it within 90 days if you pay that plus whatever else is due. The notice of sale says you owe $727,000. A lot of people say, oh, you know, I missed my opportunity to pay the arrears, so now I got to pay the whole thing. And that's not true. It's just a mechanism of the way that these things are laid out. You can still cure the arrears. So let's say at that point the arrears are $45,000. You can still do it usually up to the day of sale, but there's a rule called the tender rule in California that says if you do it within 5 days of the foreclosure sale date, they can reject the reinstatement and say you got to pay the whole thing. You can always pay the whole thing. You can sell it, you can refinance it, you can do anything like that as long as you're paying the whole loan off before the foreclosure sale happens. But if you're reinstating, if you're just paying the arrears back, you got to be really, really careful in last minute situations. As a practical rule or a practical, event, the lenders will almost always let you reinstate up to, probably the day before the sale or even the day of the sale in most circumstances. But if something happens where there's a mistake, so forth, and they foreclose and you say, well, I paid everything up, 2 days before the sale and I reinstated, their lawyers can go back and they can rely on this tender rule and try to say, no, you would have had to pay the whole amount. That's not valid. We still foreclose. So again, the enforcement of this is very rare, but just be aware of it and, be aware when a client comes and tells you, I'm going to reinstate this, or, I want to sell, but I'm behind and I want more time to sell. I don't want to sell with a foreclosure pending because I might get less in the sale, something like that. You got to understand that a lot of times they're misunderstanding or mistaken, or they might do something that takes that power away from them. And then, you put a lot of work into a sale and they put a lot of time and work into a sale and it forecloses and, they can lose substantial amounts of money in a foreclosure sale as opposed to selling the property. This is just kind of a summary of what I was talking about. The timelines are that once the notice of default is filed, you have 90 days again. And then once the notice of sale is filed, you actually have 20 days after that. But sometimes we'll set it longer. So sometimes, I'll give an example here. Let's say that a homeowner owns a home that's worth $500,000 and the balance of the mortgage is $700,000. The homeowner loses their job. They start missing payments in August of 2019. And the bank says, okay, well, they send some letters, nothing happens. They don't make any payments. On January 1st of this year, they're now behind $25,000 with all the missed payments and fees and costs. And again, this is just an example with made up numbers. And then the bank will file a notice of default. They get the notice of default. They have 90 days to reinstate it. They can go and they probably will try a loan modification and they'll apply to the bank for whatever relief they want to apply for. They really have very little leverage at that point. The bank can deny things. We'll talk briefly about loan modifications later. But if they get lucky and get a loan modification, that's great. But a lot of times they're just not going to make payments and it's going to be 90 days. And then the bank's going to set a notice of sale. So in this example, the homeowner does not reinstate. The mortgage files the notice of sale on April 1st, 2020, and then they set the sale date for April 25th. So just as an example of the timelines of what you normally see. And now the amount behind is $42,000, let's say. And so in this example, the borrower should really catch up. If they're going to reinstate, they should pay it by April 20th. They should actually pay it a lot sooner, but they should pay it as soon as possible if they're going to reinstate. If they're not going to reinstate, when the notice of sale is filed or even earlier, that's the time to start talking to an attorney, talking to a realtor, figuring out what they want to do. Because you're in real crunch time now. You don't have a last minute reprieve normally, from a mortgage. And so you got to start acting, and you got to figure out, am I going to sell the house? If so, let's get going. Am I going to do a short sale or apply for a short sale? If so, let's get the application in. Am I going to file a bankruptcy? If so, let's prepare for that and understand those options. Am I going to apply for a loan modification? If so, will that stop the sale? We'll go through that again briefly later, but this is the time at that point to deal with those options. And preferably much before then. Preferably you get them before the notice of sale is filed, so that if you're going to sell, you get that process started, because time is everything in a lot of those situations, and you want to be able to successfully sell the property, deal with any last minute issues, and also get as much money as possible so the client is happy, and it's the best thing for business also. The next thing I'm going to talk about is just the options generically when facing foreclosure in California, but I wanted to pause for a minute here and see if you guys had any questions on the foreclosure process itself that I just went through. Okay, I don't see any questions, but if you feel like asking questions at any time, just go ahead and I'll pause then. I apologize, I think I'm going pretty fast. I think I put too much information in here, so I'll just try to get through it. Okay, so when I have a potential client that calls me, and this happens all the time, they'll call and they'll say, I have a foreclosure date, I'm not sure when it is, or I think I'm in foreclosure, or even worse, I have a foreclosure date, I know when it is, and it's tomorrow. That kind of thing happens all the time. Sometimes I'd say close to half the time when I look it up or I call the trustee, like I was talking about before, they're wrong about the information or they don't have the most current information. So sometimes they'll say, my sale date's tomorrow because they got a letter in the mail from some attorney or some company that's saying they do foreclosure defense, and all they did was estimate when the date would be. It doesn't mean that that's the date. You have to call the trustee and really understand when that date is to make any informed decision. So when you're facing a foreclosure in California, I kind of boil this down to the 7 options that I would consider. Again, if you have questions, I'm happy to take questions on any of this now or after the webinar. The main ones are these. The first is you can cure the default, reinstate, you're out of foreclosure, and the problems are solved. The second one is to apply for a loan modification. The third one is to file for reorganization bankruptcy, which can be Chapter 13 or Chapter 11 under certain circumstances. The fourth one is to file for liquidation bankruptcy, which is Chapter 7. That's not usually a good option for these situations, but I'll talk about that in a minute, but it does stop the sale initially. The fifth one is litigation. You can sue the bank and try to get a restraining order to stop the sale. I'm not a big proponent of this option either. I'll talk about that in a minute as well. The sixth one is you can do a traditional equity sale. That's where there's equity in the property. You'll profit off of the sale. And that is probably the majority of what you guys do. And then the seventh is a short sale, which is basically when you're selling, but the liens exceed the amount of the profit. And so you need to get permission or agreement from the lien holders to complete the short sale. Okay, I'll try to go through this briefly. I know that a lot of this is not things that you would deal with hands-on, but I do think it's helpful to know, because if your clients are anything like mine, they're going to want to do anything they can to save their house at some point, at least the ones that are going into short sale. Usually short sale is the plan of last resort, because at least again, in my experience, most people say, well, if the bank will just give me a 2% interest rate and drop my payment by a third or by 3 times, depending on what they want, I'll be happy. I'll just stay in the home. I just wish they would do that. And so, usually you get someone who says, okay, I'm going to try a loan modification, get denied, appeal it, get denied, talk about bankruptcy, realize that it's not something that you could really afford, and then say, okay, I'd rather do a short sale than a loan modification, or a short sale than have to deal with the foreclosure. It's better on my credit. I have more control. Sometimes there's incentives from the bank to do it. There's a lot of reasons you can control the short sale in a better way. The question just came in: at what point between the NOD and the actual equity sale date can the bank block a sale through a traditional realtor? I'm not sure about the language on that. I don't know exactly how to answer that question, to be honest. But the answer is the bank can't, for an equity sale, the bank would just be paid in full because it's an equity sale. They get everything they're owed. So if there's a foreclosure sale date and you sell the house before that foreclosure sale date, the bank shouldn't be able to block it. They just have to get paid. So if they put in the demand escrow, the sale is going through, they're getting paid everything they can. To my knowledge, they wouldn't have a right to block the sale as such. The lenders, on the other hand, if it's a short sale and they're not getting paid everything, they do have the power to, again, in essence, block the sale by denying the application. And that's where that comes in. Another question, will a loan mod application delay the foreclosure sale date? I'm going to get into that in a minute, actually, in the presentation. So just very briefly here, because I want to get to that question. With a loan modification process, the bank will just send out normally, again, in most cases, a generic application. You fill it out, the borrower fills it out, they put a bunch of their information in, send a lot of financial documents, 4506T, which is similar, I know, to a lot of real estate documents, pay stubs, tax returns, profit loss statements, bank statements, things like that. They'll send it in. And just so you know, because this is really important, a lot of borrowers will be like unemployed, or they'll be making $500,000 a year, and they'll have a $3,000 a month mortgage payment, and they'll say, I want to try a loan modification. It's almost never going to work in either situation, because if you think about it, if you're making no money, the bank, it's just like a normal finance application. The bank is not going to be able to approve you for a modification, which is essentially a new loan, and say, look, you can't, if I give you a loan modification and you're making $0, what payment can I give you that you're going to be able to make? And for whatever reason, a lot of people don't understand that. And they say, well, I'm unemployed, they should work with me, or they should have to work with me, or they should choose to work with me. And again, you should know your enemy, if you will. The bank is not going to just work with you, and it's honestly not in their best interest. Same thing with a ton of money. If you're making $500,000 and you're behind $20,000 because you're missing $3,000 payments, that seems like an intentional default. That doesn't seem like something where the bank would want to give you a loan modification. So when a client comes to you and says, I'm trying a loan modification, but I'm going to do a sale as a backup, and they say, well, so you say, well, are you working? And they say, well, no. I don't know. You can kind of talk to your own resources about you want to avoid legal advice, but at the end of the day, you can kind of say, well, how are they going to give you the loan? Just go through that analysis I just did. It can sometimes help you a lot to get a jump start on a sale when someone realistically is not going to get the loan modification. And now the loan modifications are typically turned around in about 30 days before you do that. Okay, so the question was, will a loan modification application delay the foreclosure sale date? This I'm going to get to again, maybe hopefully briefly in a little bit. But there's something called the Homeowners Bill of Rights that was passed in 2013, and it was amended in 2019. That gives rights to homeowners that are both applying for loan modifications and also applying for short sales. And it's complicated. It's always changing as far as the interpretation of it. And so the answer, as a lot of attorneys will tell you, is always sometimes, and always it depends. And the big issue here is, the question is, will a loan mod application delay the foreclosure sale date? Well, technically under the Homeowner Bill of Rights now, if you submit a loan modification application, it freezes the process. They can't foreclose. So on its face, you would say, okay, well, I'm just going to, every time a sale date is coming up, I'm going to submit a loan modification application. They'll delay the sale, and then I'll get done whatever I need to get done. There's two issues with that. Number one, if you've already started a sale process, a lot of banks will just kick out the loan modification because you're trying two options at once. And that's allow them the rules. The second thing is, what a lot of banks have figured out in a response to this, and this goes for both loan modifications and short sale applications, is they say, sure, if you do this application, you can, delay the sale. If we get to the foreclosure sale, it'll be delayed. But we have the right to, determine when the application is denied. And once the application is denied, then you're not under an application anymore, and we can go forward with the foreclosure. So in reality, what that means is you submit a loan modification application 5 days before the sale, the bank can look at it and they can receive it, and they can say, okay, received. Now, we only have 5 days to review. That's not enough time under our underwriting guidelines. We're going to deny the application. Deny the next day, foreclose 4 days later. So in that sense, you know, most of the time you put in an initial loan modification application, it will postpone the sale a few times, just the same way as a short sale application. If everything's in, if it's complete, you got to make sure it's complete. You got to make sure to follow up with the bank. You can't just throw something at them and say, you know, they can't foreclose, which a lot of people do. But if they foreclose, you don't really have a leg to stand on. You got to make sure it's complete, and you got to ask them, you know, now that you have the complete application, how long will it take to review, and will the sale be postponed? If you do those steps, under most circumstances, the bank will postpone the sale. Sometimes people will try that, like, you know, 5, 6, 7 times, and the bank will start saying denied, you know, no change since the last application. That takes them 10 minutes to figure out. So there are defenses for the banks. They can't postpone the sale, or they don't have to postpone the sale whenever an application is in, only when an application is in and it's pending, and they can unilaterally terminate that application and say it's no longer pending. So they kind of have the trump card in that sense. What you can do is, you know, to be very cautious about this and to really take advantage of the way that the laws are written, is to call ahead of time as soon as you know that a bank is, you know, has your client's file, that your client's servicer is this bank. Call them and say, you know, if they were to submit a short sale application, or if they were to submit a loan modification application, how long before the foreclosure sale date do they have to do that? They have to tell you that information, and then you're not flying blind. Then you're going in and you're saying, okay, well, I have 28 days. I have to do it 28 days early. I have to do it, you know, 15 days early, whatever it might be. 28 days would actually be difficult because you wouldn't necessarily know the sale date yet. But, you know, whatever the timeline is, they're allowed to do that timeline as long as it's within reason. And a lot of them do up to a month that I've seen. I think I've seen 35 days actually. So you just have to make sure you're aware of their policies. And if you get the application in on time and it's complete, then they have time to review, then they'll probably postpone the sale. If it's last minute, it's worth a shot. It's definitely helpful to call them and follow up and say, you know, I submitted this and request the sale date be postponed. Oftentimes they'll do that, but sometimes they won't. And in those circumstances, it's actually helpful to understand a little bit about the next option, which is bankruptcy, because bankruptcy can be very helpful as a backup option for some of these people. Again, a lot of misunderstandings about bankruptcy. I'll go through just very briefly a couple of things. And again, you can feel free to email me with any specific situations. This is one of the practice areas that we do encounter a lot and help borrowers with a lot. Let's say that you get in that situation that I was just asked about. You get to the end, right before the sale, you try a loan modification application. They say, we're not sure if we're going to postpone it. 2 days before, they say it's denied, we're not going to postpone it. The borrower has, you know, $300,000 of equity in their home, and they've listed the home with you. So you're sitting there, you've done all this work, you got up to the sale date, and it's basically turned into a hopeless situation. You can file a Chapter 13 bankruptcy. A lot of people will file Chapter 13 bankruptcies as skeleton petitions just to stop the sale and then let it dismiss. As an attorney that does a lot of bankruptcy work, I can tell you that's not good, and it's a little bit dangerous. You know, a lot of people get lucky and never have to deal with the trustee, but the bankruptcy trustee is under the Department of Justice, and some people that try that, they end up getting sanctioned. They end up having to go to court and explain why they did it, why they file these cases without the intent of following through, which is considered to be bad faith. And sometimes, you know, what they'll do is they'll say, I have no idea. My realtor told me to do it. They told me, you know, you should file bankruptcy. And then, again, it has a lot of ramifications. It's giving legal advice. It's giving bad legal advice. And you can get sanctioned as well. And there, you know, I've seen things like that go sideways. So just be careful with any kind of bankruptcy advice like that. Refer them to an attorney, refer them to legal aid, whatever makes sense for them. But with Chapter 13, it will stop the sale in almost all situations. The automatic stay will go into effect. It's federal law with a couple exceptions. I'm not going to get into huge detail on that right now, but if they filed prior bankruptcies in the last year, then the automatic stay may not apply or might apply for a limited amount of time, and you'd have to go to the court and explain why this case is different and explain why the automatic stay should apply in that case. So again, be careful. Always ask them. I mean, you don't want to get too much into the weeds in this anyway, but always find out if they filed prior cases. That will impact, so they could file a Chapter 13 if it's their third case in a year. The bank can still sell it. It won't stop the foreclosure sale. the question was just asked, wouldn't it take a couple of days to file a bankruptcy if the sale is the next day? I suppose it would depend on the attorney. There are some things you need to do before filing a bankruptcy case. The client would have to take an online course. It takes about an hour. It costs about $10 before filing. Had to fill out some paperwork. Right now, all of this is remote. It's pretty fast. I can speak for myself. I file bankruptcy cases for people the day or two before all the time. It can take about 4 or 5 hours if the attorney is good. Can put everything together. The client is communicative and can get the information. Because what you can do is you can file what's called a skeleton petition that only contains about 8 pages of information, as opposed to the full petition, which contains about 60. And then you just need to file the rest of it in the next 2 weeks. So there's a mechanism for filing these very, very quickly. But it's important that the client has time to really go over their options and understand with the attorney, because you don't want to get into a repeat situation where you're just filing bankruptcies and then you don't have any idea what to do on the other end of it. But in answer to the question, it happens all the time, especially with kind of good and communicative attorneys. You can get someone could call me right now and I could have a petition filed by 3 p.m. probably, if that was, necessary, and if there was a sale date, in theory at 4 p.m. You got to be a little careful filing the same morning, which happens sometimes. There's some interesting rules about whether the time of the sale can be backdated to before the petition. So I never file same day, but I'll file the night before all the time. Let me kind of briefly go into the other 2 chapters of bankruptcy. There's a Chapter 11 bankruptcy. This gets very complicated. This is typically for businesses, but it can be for individuals. This can be very effective in certain circumstances, because you can actually, let's say I had a house worth $500,000 and another one worth $400,000. And the one that's worth $400,000 is a rental property and I owe $700,000 on it. Through a Chapter 11, you can actually force the bank to reduce that balance to $400 if you can get or $400,000 if you can get a plan confirmed. You can reduce the actual loan to what it's worth. This might come into play a lot if the market goes down. So Chapter 11 is for businesses typically, but for some individuals, usually they have higher debts. If your loan, for instance, is more than 1.2 million in most circumstances, you can't file Chapter 13. You have to file Chapter 11. So they serve the same purpose. And just very briefly on this, a lot of people file the bankruptcy just saying, I'm going to delay or whatever it might be. You can file either Chapter 13 or Chapter 11 and say, my plan is to sell this house. I've got it listed. I just need 90 days to sell it. You file the case. The plan isn't to reinstate your arrears or to pay all the debts back necessarily. The plan revolves around the sale of the house. It's a creative kind of plan. It's not the way that Chapter 13 is built. But both Chapter 13 and 11 you're allowed to do that. And it's a very important mechanism if you're behind and if you're facing a foreclosure sale date, and if you don't really have the money to reinstate, but you have $300,000 of equity and you don't just want to lose it all in a foreclosure. And so you want to file a Chapter 13 and say, I'm going to sell my house within 90 days. I'm going to pay these debts, this debt I dispute, and I'm going to litigate that through the bankruptcy case. And I'm going to use the automatic stay to be able to have that time so that they can't foreclose on me for 90 days. It's a lot better than trying to just keep delaying the sales with modifications and hoping the bank will back it up. That's just a very unreliable method. And then very quickly, Chapter 7 is liquidation bankruptcy. And if you've got a lot of equity in your home, this is a bad idea, because the trustee will just take the house and sell it and pay your creditors. If you don't have a lot of equity or assets, you can do this. If you haven't filed prior cases, you can it'll stop the sale. But this is not reorganization bankruptcy. So a bank can come in and they can tell the bankruptcy judge, this person is not trying to reorganize. This case is going to be over in 3 months anyway. I want relief from stay. There's no equity here. I'm going to move forward with the foreclosure. The judge will usually grant that. And then you'll be in a really weird situation, because the court would have to approve any sale, but the bank's moving forward with a foreclosure during the case, and people can get completely stuck in a Chapter 7. Like a realtor trying to sell the property, they may not have authority. The bankruptcy trustee may be the only one with authority to deal with the property that the debtor has. So when debtors file random cases of bankruptcy, sometimes they'll file a Chapter 7. You can't automatically dismiss a Chapter 7, and so you can kind of get stuck in limbo. No one can do anything, and the house can foreclose, or the trustee could sell the property, and you as a realtor can lose all your control over the situation. And so you want to avoid that unless, talking to an experienced bankruptcy attorney and they say, well, that would be okay in this situation because of X, Y, and Z. I'm going to answer 2 quick questions on bankruptcy here. How much does it cost to file for Chapter 13 bankruptcy? That would, again, kind of depend on the attorney. In the Southern District of California, they have guideline fees that the court has issued that are typically the price for the entire 5-year case, at least unless something unusual happens. For regular cases, what I would call regular cases, consumer cases, the guideline fee is normally $3,900. And for business cases, it's usually $4,400. A lot of attorneys will file the cases for nothing down or for a little down, and they get paid back through the plan. So through the plan payments that the client will pay the trustee. So as far as upfront costs, a lot of attorneys will just say, you can file the Chapter 13 case with me. The only cost to file it is the court's filing fee. And the court's filing fee is $310 for any Chapter 13 case. It's about $1,700 for Chapter 11, but that would be a different situation. So in many circumstances, you can find someone that will just file the case for $310 for the filing fee and take the rest of the fees through the plan. That can be negotiated between the client and the attorney, but that makes it very affordable, and that's something that I think is a good idea because a lot of people don't have a lot of money, and that gives them the opportunity to buy the time to get done what they need to get done without having to pay a bunch of money up front. Another question is, can you leave your property out of the Chapter 7? And that's a very easy answer. The answer is absolutely not. You can't leave any property out. You also can't leave any creditors out. You have to disclose everything. Everything is part of your bankruptcy estate, including your interest in trusts, including your interest in businesses. So if you file a Chapter 7, you have a business, the trustee could theoretically step into your shoes and say, I'm going to shut down this business, or I'm going to take control over this part of the business. Chapter 7 you really need a good attorney to deal with complicated Chapter 7 cases or cases where there's any kind of assets or any kind of income issues, because they're the most common type of bankruptcy. There's a lot of firms that do them, but there's a lot of minefields involved in that and landmines. And you really have to be careful about stuff like that, especially in conjunction with the sale process. If the trustee sees that you've got a lot of money, a lot of equity in a property, and that you're trying to sell it, and they get the case, and you've got $50,000 in credit card debt, they're going to jump on that because they get paid out of the sale. They get paid out of whatever they can get for the creditor. So they will charge $50,000 in fees to the homeowner probably to sell their house, take their house, pay their creditors, and give them whatever's left. And they'll probably just pay their credit, probably just sell it at whatever price is necessary to pay everyone off. They don't care about maximizing the profit for the debtor or the homeowner necessarily. So again, just be very, very careful. You can't leave anything out of a Chapter 7. You never want to hide anything from the court in any chapter of bankruptcy. They're really, really good. They have auditors. They have people. They have a lot of access to a lot of systems. People that have tried to hide property, including property, in faraway countries. I have seen the trustees at the hearings under oath ask these people, well, do you have a house in, Malaysia, or do you have a house in Mongolia, or do you have a house in Peru? They can find things. So hiding is not to say that the question meant, that you intended to hide it, but some people think they can. And it's a very, very dangerous proposition. You got to be careful. Very, very quickly, a lot of attorneys and a lot of companies think and promote the idea of suing the bank because of anything they can think of. They'll do what are called forensic audits. I'm not a big fan of forensic audits. I can talk about that separately. They will sue the bank because, for instance, they say, well, you can't prove the chain of title, or you have an invalid assignment, or it was robo-signed, or, there's 10 or 12 different things that are commonly come up. Very, very rarely work. I've been in court a lot where these cases are thrown out. And the most important thing that people need to know is if you file a lawsuit, it doesn't automatically stop the sale. The bank may stop the sale just to, for their own prevention of damages and so forth. But a lot of banks will move forward and still foreclose and say, look, if anything you're saying is true, you can get damages, anyway, after the sale. It doesn't mean that we have to stop the sale. In order to stop the sale, the foreclosure, you would have to file a lawsuit and file a request for a temporary restraining order or a preliminary injunction. And you'd have to show the judge on a very last second basis, probably, why the case has a likelihood of success on the merits, meaning why this is not just a thrown together lawsuit meant to delay the sale. Honestly, most people that do this can't meet that burden because they just kind of copy and paste the same kind of stuff And most of the time, the things that these people bring up, a lot of these companies I really dislike, is they confuse people, think that they have these rights they don't. You got to be really careful about whether the case has any real chance of success. Otherwise, filing a lawsuit can mean next to nothing. And if anything, the bank can just add their attorney fees and charge it to you and to your lien. So you got to be really careful with that. Okay, so does anyone have any questions on any of those options, bankruptcy or loan modification or anything that I've gone through? Okay, the next options are going to be the equity sales and the short sales. You guys probably know a lot about this already. If the homeowner is selling while the foreclosure process is ongoing, all the stuff I've been talking about to this point is important to take into consideration. You'll know the timelines, you'll understand how long you have to sell, and then it's just a negotiation between you as the realtor and the bank's real estate department, in other words, sale department or mitigation department or whatever they call it. You can say, here's the say, the house is in escrow, it's going to close in 20 days. Can you please postpone it, the sale, by 10 days? Here's, proof of everything. Here's the settlement statement. Here's the HUD one, however you want to explain it to them. You say, it's in your best interest just to wait. You're going to get paid. Will you please do that? You want to do it as quickly as possible, as far in advance of the sale of the foreclosure as possible. And usually banks will work with you, and they're not going to try to foreclose if they really think that they're going to get paid in 10 days in full. It's a lot more hassle for them to foreclose. I've seen banks postpone sales when we submit just kind of marketing plans. Sometimes there's no sale in process. Sometimes there's nothing in escrow yet. We've had some offers. We'll ask for 60 days. We'll say, we just need a 60-day extension. There's a lot of interest. That is really up to the bank. So the sooner you talk to them, the more you can kind of get through to them. Some of the banks are good with that. Some are just kind of robotic and they won't help you. They don't have to help you. You have these other options that I talked about if they won't. But if you're selling, you want to just talk to them, and communication is everything, and see what their options are, because everyone's different. And despite everything I'm saying, if you talk to the bank and ask them their options for any of these things, other than bankruptcy, they'll talk to you, and it'll be helpful to understand exactly what the options are. Another quick note, a lot of clients come to me, a lot of realtors come to me saying, I was about to sell this house, and then this last second tax lien or judgment lien popped up. The client doesn't think they owed it, or the client filed bankruptcy a long time ago, and it should be off the house. A lot of clients think that second mortgages and judgment liens are removed because they filed Chapter 7 bankruptcy. Normally, they're not. Junior liens, HELOCs, are never removed through Chapter 7. Judgment liens, you have to file a separate motion. And a lot of people will just say, I only have one mortgage because they filed Chapter 7. Make sure to ask that question. Make sure to not be surprised at the last second, to find out what the liens are. Don't just rely on your client's word. They're not, misrepresenting anything necessarily, although sometimes they do. But usually they're just confused, or maybe they had a bad bankruptcy attorney who told them that the second mortgage would go away. It happens when it didn't. You need to file a Chapter 13 or 11 and complete the plan normally to strip a second and file a separate motion for that. So just be aware of that on the front end so that you don't have to deal with it on the back end. A short sale is any sale where the net proceeds are going to fall short of the debts secured by the liens. You need the consent of all lien holders to complete a short sale. Right now is a better time to be doing short sales because of a lot of the postponements I'll talk about in a second here. It can be a very effective tool for avoiding foreclosure. A lot of times, like I said, it's the last resort. It can be the last resort if sometimes realtors are very good and they can explain the benefits well to the homeowners. But I think it's human nature for people to prefer to stay in their homes, and they're not necessarily going to see a whole lot of benefit from doing a short sale. To them, it's, a lot of them think, well, if I do a short sale, I'm not going to owe the difference. And so I want to do that. That obviously is not true, as we talked about before, but a lot of people think that. But it's cleaner to do a short sale for a lot of reasons, because you get consent, everything's known, no one's going to come back after you in the future, that there's not going to be any confusion. You kind of have everything wrapped up and you can move on. It's better for your credit. Lenders will often prefer short sales because you're the one doing the work. You're the one selling it. They don't have to do an REO, take it, market it, put all that expense into it. So it's a preferable option often for lenders. And, what I talked about before with the homeowner bill of rights is really important. You just want to call. You get a client whose servicer is Caliber. You want to call Caliber as soon as you possibly can and say, my client is looking to do a short sale. what is your short sale procedure? How soon before any foreclosure date do we need to get the application in? And you could have that all in front of you. And that's the best way to do it. Same as an equity sale, you want to review for unknown liens. And a lot of times, this goes beyond the scope really of this presentation, but you can, sometimes you'll apply for a short sale and they'll say, you know what, the price isn't high enough. We need $490 and you're giving me $430. Sometimes you have to go and get your own appraisal, and sometimes it's worth it. You can get an appraisal to show $430, submit it, work with the bank, explain the math to them. You can sometimes get, again, banks are different, but some servicers will kind of negotiate with you a little bit, because at the end of the day, like I said, it's in their best interest often to do a short sale rather than a foreclosure. The homeowner bill of rights, we talked about this before, and I don't want to go into great detail on this right now, but a couple of quick things. Homeowner bill of rights, a lot of people will file lawsuits based on this and try to stop foreclosures, and it's a rental property or it's a vacation home. The homeowner bill of rights only applies to somewhere you're living in, actually living in, not fake living in and having a utility bill sent to the property. And so with that in mind, you want to make sure that the client who has a rental property doesn't say, I'm suing the bank under the homeowner's bill of rights, which is usually what the lawsuit is based on, or the homeowner's bill of rights says they can't foreclose because I have a loan modification in. It doesn't. It only applies to a property you're residing in. The whole point is to protect people that are homeowners in their homes. And banks have started to file motions and to seek fees against clients and their attorneys who file these lawsuits when they're not living in the home. So this is just kind of started. There's been enough of these where it's been a fake delay tactic. You gotta be really, really careful about that. The laws were amended in 2019. They actually improved the short sale options, because before, a short sale had to be improved in writing by all parties, and proof of funds or financing had to have been provided before they would stop a sale, foreclosure. In 2019, they amended it. They said you can't record an NOD and NOS or conduct a foreclosure sale upon the receipt of a complete application for foreclosure prevention alternative. That's a loan modification for a short sale. But as I was talking about before, they can just deny it and say we didn't have enough time. Our policy is 21 days. Our policy is 15 days. Or they can say we deny it right away because you've applied for this 7 times before and nothing has changed. So be aware, because a lot of people say, well, I submitted it. It was a good question before. I submitted this, so they have to back up the sale. No dual tracking. It's called dual tracking to be able to, foreclose or proceed with foreclosure while an application is in. That's not how it works. It's complicated. You got to be careful, and you've always got to check and make sure that they're aware of everything. You just don't want to have the house sold or foreclosed and then come back and say, you violated something. 9 times out of 10, it's not going to work. And even in the 10th, it's going to be hard to get it back and sell it again. Again, these are the cautions that I talked about before. I want to kind of get through this because I want to talk about the coronavirus updates. Always communicate with the lender. Let me see. I have a question about 1099 taxes, and I cannot, unfortunately, I can't give tax advice. I'm not allowed to in a presentation like this, and I'm also not a tax attorney, but I would definitely refer any tax questions to an accountant or a qualified person, especially in short sale situations. Make sure that your clients are talking to an accountant, or at least, I know that the forms give some protection legally, but it's just good practice to have them be aware of any kind of tax ramifications. Those laws are changing and depend on a lot of things too. Okay, so with regards to the coronavirus pandemic, this is the very important part of this. The laws are changing, or not necessarily laws, but state orders, protections, federal orders are changing constantly right now, day to day, week to week. There's a lot of scrambling. There's a lot of gridlock, obviously, with the way politics works. And so you've got different protections, different kind of protections, semi-protections, and a lot of confusion. I'll go through this step by step. You can reference it, and certainly you can email me if you have any questions, or you can look online. There's lots of resources on this. And like I said, the laws and rules as of today are probably going to be different in 2 weeks. So I'm going to give you some guideposts here, and you can certainly follow up on some of these bills and some of these things. There's a couple that might dramatically change everything. The first act is the CARES Act. That's the big federal act that was passed through Congress. If the loan it's a servicer of a federally backed loan, which means Fannie Mae, Freddie Mac, HUD, some of these agencies, is servicing the loan. They own the loan and there's a servicer. they cannot initiate any foreclosure-related eviction or foreclosure sale until at least June 30th. That was put into place on March 18th. And that means that a lot of banks are backing up sales past June 30th. That's right now, they're likely to extend that further, but it only applies to federally backed mortgage loans. And so you need to find out, and you can ask the bank itself, you can ask, any number of resources, but you need to find out if it's federally backed, because otherwise it doesn't apply. A lot of people think that this is a blanket moratorium on every loan, and it's not. I see Mr. Cooper moving forward with foreclosures. I see other servicers moving forward with foreclosures. You just have to be really careful. There's websites right here. You can write them down. I'll give you a minute to write them down if you want. Fannie Mae and Freddie Mac have online websites where you can look up if a given loan is with them. That will obviously help to know if this foreclosure moratorium is in place as to your client's loan. Again, this may be a moot point after June 30th. It's only extended to June 30th right now, but it may be extended further. And so these are important links to look up. You can just also, if you can't get it, you can just look up Fannie Mae loan lookup tool, Freddie Mac loan lookup tool, etc. And this is an important resource, again, to look these up. You can also ask the servicer, and that's the easiest way, is to say, who owns this loan? Is this part of the federal moratorium? It's all part of the same conversation. I would just give, as a blanket piece of advice, call the servicer and say, what is covering this loan? Is there any kind of foreclosure prevention? Are you going to postpone? Is there a forbearance option? In March, additionally, California did stipulations with Chase, Citi, U.S. Bank, Wells Fargo, and some credit unions and state banks to commit to a 90-day forbearance period. That would be through about June 20th. And that's for COVID-affected borrowers. There's a minimal threshold they have to do to show that they're affected by COVID, but it's usually just kind of rubber stamped. And you can call and request a postponement. I've had that happen with a lot of my clients. They will just call and they'll say, can I get a postponement or forbearance on my mortgage? And they'll say, yes, we'll give you 90 days. Sometimes they'll say, if you want to apply for another 90 days after it, you can. Some of these are because they have to. Some of these are because they stipulated with the state. Some of them are because they want to for PR purposes. Some of them may be, because their own internals say that it's better for them to do the forbearance rather than foreclose right now. So again, just asking them is better than trying to guess at which one might apply. But those 4 banks that agreed to 90-day forbearances, Bank of America only agreed to 30. And again, there's confusion over who's the servicer, who's the owner. Just call the servicer and ask if any of these apply. Always exercise caution with this. You never want to assume that it's going to be postponed because the loan is with Bank of America and there's some kind of moratorium. It drives me crazy how some of the clients will call and just say, I'm not worried about it right now, but I am going to want to sell in like 3 months. So how do we get that process started? Or I want to file bankruptcy, but we can do it in 3 months. Because they can't foreclose on me until July or August. Just really, really dangerous. They could postpone, they could not postpone. And the first thing I tell them is, you got to take a step back and restart the thinking process here. And let's make sure that what you're saying is accurate. Because if it's not accurate, you can't come back and get the house back. A lot of servicers are being really cautious right now. They are postponing foreclosure sales even if they don't have to. Again, it's really hard to know. Some of them, you may not know exactly why. Some of them may be doing it because of an internal agreement with the federal and state government, local government. The governor actually gave authority to local governments. The governor of California gave authority to local governments, mayors, so forth, to do individual moratoriums on foreclosure. So it could be that someone in the city of Vista or someone in the city of Long Beach, could not be being foreclosed on because of that. But someone in the city of Carlsbad could be foreclosed on. So it's just impossible to guess. You just have to kind of understand the big picture and know this. One more quick note on this. I've seen it over and over and over again. When the forbearances are granted, so let's say that Mr. Cooper will grant a 6-month forbearance. The homeowners, I'd say 80% of them will call me and say, I got a forbearance, we don't have to worry about this for 6 months. And I'll say, are they putting it back into the loan, or do you have to pay everything back at the end of 6 months? So you're going to miss $3,000 payments for 6 months. Are you going to be able to pay $18,000 at the end? And they say, oh, no, it's a forbearance. We don't have to pay it. And I asked them to send me the paperwork, the documents that the bank sent. And every single time that I've seen it, which is probably like 20 or 30 now, it says After the forbearance period is over, you can try to enter into a modification with us, which of course will be the bank's decision. Or, otherwise, if you don't get the modification or if you don't try, you have to pay us back the full thing. It all becomes immediately due at the end of the forbearance period. For a situation like a sale, it's very helpful. For a situation where someone's current and they're able to make the payment, but they just want a forbearance, it can dig them a hole that they can't necessarily get out of because they misunderstand what the forbearance means. And so, again, this is just really confusing. I understand from their perspective, from anyone's perspective. If you say a forbearance, you don't usually think, well, I'm going to have to immediately pay $18,000 back in 6 months. But that's the way that this is trending. And I really think that in 6, 8, 10, 12 months, you're going to have a wave of defaults based on this misunderstanding, based on the economy and other things also. But this misunderstanding, I think, is going to add to that. And so as realtors, I think they're going to be very busy dealing with some of these situations, finding people that are behind that didn't think they would be behind and wanting to do a short sale or a sale quickly. And that's, again, where all these other options come into play. Okay, very quickly, I don't know if I'm going to be cut off here by anyone, but I'll try to make this in about 5 minutes. There's two bills that are going through the California State Legislature, which could change everything, could give us a lot of options. The first one and the most important one, I think, is California Assembly Bill 2501. This is pending. It hasn't been put into law. It would implement what's called the COVID-19 Homeowner, Tenant, and Consumer Relief Law of 2020. What it will do is it would implement an automatic mandatory 180-day stay of foreclosures for affected borrowers. Again, we don't know how you would prove you were affected, but there's almost anyone can say that they're affected legitimately, I think, by coronavirus. I mean, whether it's expenses, whether it's not being able to go to your job, whether it's medical concerns, whatever it is, I can't imagine that the bar is going to be that high. And for any borrowers experiencing a hardship, which again is what I just talked about, the servicers must grant a request for 180-day forbearance plus another 180 days if the borrower requests it. So if this went into play, we're not going to have to guess at which banks will give it, which banks won't, whether it's Fannie or Freddie, whether it's a state bank disagreed with Governor Newsom on some kind of stipulation. This will just be a blanket, easy to know moratorium, the kind of thing that I think a lot of people think already exists. There's a lot of back and forth. There may be more caveats put into this before it becomes law, but I would write this Assembly Bill number down just to follow it and see what happens. I'm not an expert by any means at the legislative process in California, so for all I know, it could be being passed right now. But it's probably going back and forth, and if this passes, it's going to, I think, affect everything I'm talking about and give a lot more protection for homeowners, which in turn will give a lot more time for you to be able to do sales, short sales, anything of that nature, and I think will help everybody out. There's a couple clauses right in this bill, which again is being written, that, for example, the servicers must not demand a lump sum payment of forbearance arrears at the conclusion, but must review borrowers for affordable reinstatement and modification options instead. That goes to exactly what I was just talking about. They saw what's been going on, and they're trying to prevent that from happening because they see this default wave coming. I don't know if that's going to stay in there. The banks have a pretty powerful lobby, so it may not make it into the final bill. But keep an eye on that, because then people are going to say, well, I don't need to sell right now. I got 6 months and another 6 months. And then, at the end of that, they have to give me a modification. Well, that's probably not going to be true. That's probably going to be wishful thinking. And so you really want to know what this bill says, so that you can say, well, that's not really the case. There's a chance you might have to pay $70,000. So, why don't we do this? Why don't we have a sale going on in the background, the sale process? I can see if I can get you, an amount you'd be happy with. And then you can wait, and then if after 12 months they don't give you a modification, we can be ready to sell, and I'll be here as a backup. And that way you can have the best of both worlds, and you don't have to worry about not having a backup plan. And that, I think, is an effective method and approach for someone in that situation, because you're going to get a lot of people who say, pressure's off, I got 12 months, who knows what happens after that? I don't want to sell right now. I like staying in my home without paying anything. And it's important, I think, to come up with an effective strategy to at least have a backup option for them and keep them going, so that they don't wait the 12 months, find themselves, $80,000 behind, try a modification, not get it, get upset with the bank, sue the bank, and then get foreclosed on and lose $300,000 of equity when they could have all along had a realtor ready to sell the house on a moment's notice, prepared in case the modification was denied. That's how I would approach it, and that's just kind of a, not legal advice at all. None of this is actually legal advice I have to say, but just a suggestion for for a general approach. There's another bill in the Assembly right now. It will create a moratorium on recording, well, if it's passed, would create a moratorium on recording notices of default and notices of sale for foreclosure for residential properties while the state or local declaration of emergency is in effect and for 15 days thereafter. This one, my guess is will get passed easier and faster. I think that this one will be kind of mooted out. It will be made, not to really matter as much if the other bill passes, because the other bill will essentially cover this as well. But this one's a little broader. It would apply also to property tax sales, unlawful detainer proceedings, and executions of writs of possession. So if someone gets a judgment for $200,000, they put a lien on someone's house and they go to court to sell the property, which is, happens once in a while. This would freeze all of that, in conjunction with, or in addition to the judicial foreclosure protections that are already there temporarily. And then, just as kind of a general thought, all of these things are in my opinion, Band-Aids, probably necessary Band-Aids, but they're not meant to last forever. And a lot of people are going to fall behind with wishful thinking. It's human nature. They're going to say, I'm going to get my job back in 3 or 6 months. I'm going to be able to pay this all back. I'll be fine. And just the facts are that a lot of people won't be able to do that because of what the economy is going through and everything else. And they're going to need to sell or to short sell or to file bankruptcy or to do a loan modification or one of these options. They're just going to need to in numbers that I think are exponentially higher than before. I think there's a lull right now because of all these protections, but it's going to end up, depending on what the federal government and the state governments continue to do, there's going to be diminishing protections. And at those points, they're going to have to jump into something or they're going to find themselves with the back to the wall and needing help. And so that's when it's just really helpful to know, well, maybe they can file a Chapter 13 bankruptcy and, sell within 90 days if there's a foreclosure sale day coming up. Or, maybe they can, we can get it listed, try to get it postponed with the bank. And if they won't, postpone it, then we can look into Chapter 13 bankruptcy. We'll have that as a backup option. My experience has just been that the more backup options you have, at least 1 or 2, the more comfortable the client is and the less danger there is that anything will happen at the last second. Because as you guys know as well as anybody, there's all sorts of things that can happen when a sale is about to close that are unexpected and very, very hard to anticipate. And that's just a very dangerous combination in conjunction with a foreclosure sale pending, because you don't want to be at the mercy of the bank with nothing else, with no backup plan, and have it foreclosed for all the reasons we talked about. And I think there's going to be a lot of defaults, probably late this year, probably early next year, no matter what these protections kick in. If there's that 6 to 12 month moratorium, it'll probably be more towards spring or summer next year. But you're going to have a lot of people who need help. And a lot of people who feel misled by the bank and are probably going to want to sue the bank. And they're going to be relying on these laws. They're going to have a lot of companies that are trying to grab their money and kind of take advantage of it and telling them to sue the bank when they may not have a lawsuit. And so it's just really, really helpful. This is what I try to do in my profession, but also for realtors, to kind of be the voice of reason and understand and empathize with the situation, but understand that most of the time here, and you can see it right now, the banks are telling you, you're going to have to pay this back. And you're going to have to deal with this. It's not an endless forbearance where you don't have to pay anything or worry about it. People are choosing to ignore it or they're misinterpreting it. And there's going to be a lot of people saying, wait, how did this happen? Or what's going to happen now? Misunderstanding it. And I think this information is helpful for background to understand, all of that. I'm going to put this general disclaimer up here. It's just kind of general legal disclaimer. Every situation is different. None of this is intended to be legal advice specifically for a given situation. It's just for background. Again, I'm more than happy if you want to email me. I can set up a phone call or answer some questions by email. Happy to help with any situation regarding anything regarding foreclosure, with bankruptcy, with short sales, with loan modification. And certainly would be happy just to kind of give advice if you're in a tough situation in the future or now. And then this is my contact information. If you guys want to email me, you can always email me. That's always best because I'm on phone and cord and so forth a lot. You can email me. My email address is amoher@morelaw.com. It's up on the screen right now. I'm getting a lot of questions about whether or not I will be releasing the slides or be able to see my presentation later and so forth. I don't know the answer to that. I don't have a lot of experience with this. I think that the people running it probably I believe are going to post it on the website, but I don't know. Can I bring you guys back? Are you there, Shirley? I'm not, I believe, my understanding is that it will be posted on the website, and I think you can contact, what I can do is if you want to contact me, if you're not able to access it, just go ahead and email me, and I'll get the information from Shirley, and I'll be able to respond and tell you where to find it. And I think all of this will be up there. Before I go, I can take a couple minutes if you guys have any questions on any of this. There, the chat is just showed the website. You can go to nsdcartv.com to view the entire recording. And I'll just wait a minute here. If do you guys have any other questions on anything we've been through? Okay, so the website, someone asked if I could repeat that. I think it's on the chat. I think you guys should be able to see the chat, which might be easier. It's from NSDC Association. But the website is www.nsdcartv.com. Let me see. Someone, I can't get into very specific legal situations. If you want to email me separately with the question that I just had about the parents' down payment, I can try to address that. Someone asked me, what do I charge for consultations? I do free consultations. So I'm happy to answer any questions and kind of guide people in any direction. I also work with realtors a lot who someone wants to file a bankruptcy case or wants to deal with their house in whatever way they're trying, but they want to do a sale as a backup. So I can take the legal part, and then if whatever they're trying doesn't work, or if they change their mind, the realtor can be ready, to do the sale. And I work kind of hand in hand. I can't trade referral fees or anything like that. There's all sorts of rules, both from the real estate side and the lawyer side. But I can provide legal services and communicate with the realtor, and that usually works very well. Let's see, NSDCARTV. If you look at the chat, you should be able to see it. So I'm happy to give free consultations to either clients or to realtors or anyone to go over any kind of situation. I deal with lots of complicated situations, a lot of them last minute, and would be happy to kind of go through any of this. And like I said, I mean, there's going to be a lot of advancing and changing information in the world right now, just like with anything else. And so this is going to be an ongoing thing where we all need to stay educated and be ready, because there's going to be a wave of opportunities and work, I'm sure, coming for all of us. So with that, I think that's all the questions. I'd like to thank everyone for tuning in. And like I said, I'm more than happy to answer questions if you want to email me. And I hope you all stay safe and take care.